right, well, wonderful. I am pleased to introduce Jerry Summers as our speaker today. Jerry has a very diverse background. He holds a Bachelor of Arts degree in Pastoral Ministry from Trinity College, and he has an MBA in Marketing from the University of Liverpool in the United Kingdom, so I'd love to hear more about that. He retired as the Chief of Police from the City of McCall in April of 2013, and he's currently the CEO of Conflict Resolutions, LLC. Jerry has written and published 4 books since February of 2015. 3 are in a 4-part fictional series about a female serial killer, and the 4th and final book is coming out this fall, so we'll have to take a look at that. That's called Tarnishing of the Badge, for a recent nonfiction work. That's a different series. Jerry speaks extensively about the need to foster public trust, ethics, and transparency in government and law enforcement. So today we are going to hear why self-policing without transparency never works regardless of the industry, and how many industries, including law enforcement, have failed to appropriately self-police. So there's plenty more, but I want to save some for you to say, so please welcome Jerry.
Thank you very much, and I want to thank the Better Business Bureau and Emily for recommending me, and I want to thank the, did we lose that? The Idaho Crime Prevention Association. I wanted to get it right, for having me. It's an honor to be here. We're going to start out with a quote from Sir Robert Peel. And Sir Robert Peel said, "The police are the public and the public are the police." Now I want you to think about that for a minute. In that the difference between a citizen and a sworn officer is the trust that the community gives to that sworn officer. That sworn officer has the right, by the trust given, to interfere with or take away your liberties. Your right to freedom, temporarily through arrest powers, and even to the point of a lethal action if necessary. The average citizen doesn't have that right to do so. Now the trade-off for the police department with the additional authority that they get is, quite frankly, it's the trust that the badge represents. I want to take a moment and just put everything into context for you. In 2010, I was noticing a trend that was going on, and I decided to write my MBA dissertation on law enforcement decertification, shifting paradigms of ethics, morality, and politics from law enforcement's traditional approach to a resource-based view. Now that's a very academic title, and all it basically means is that the solution for egregious actions of law enforcement officers within the law enforcement profession is decertification. I believe there's some steps missing in there. I believe there should be some abilities to suspend certification for a period of time, and some other actions through counseling and disciplinary actions and progressive discipline that currently the law doesn't allow. It's either you're decertified or you're not. So when you have minor violations of the code of ethics, then it's difficult for the administrator to deal with that because their hands are really tied. The badge is a symbol of trust, as I said. When officers are certified, they swear an oath to the Law Enforcement Code of Ethics, also to the Constitution of the United States, that they will enforce the laws impartially. They will be exemplary in obeying the laws themselves. They will not let prejudice, political affiliations, friendships, or anything like that interfere with their action. That's a difficult and high calling. In fact, the Code of Ethics actually says they will be exemplary in thought and deed. Now, thought is a little extreme. Deed is another thing. Edmund Burke said, "The only thing for evil to triumph is for good men to do nothing." I want you to think about that for a minute as we start talking about transparency. Now, I'm also going to tell you that what you're getting is a 30,000 foot view of a presentation that really is about 4 hours long. So I'm going to hit it very quickly. We're going to hit the highlights on that, and we're going to go from there. Originally, the first third of it is going to sound somewhat negative. It's going to sound like I'm attacking law enforcement. Please understand, I'm not. I'm pointing out what it's taken to get us to the point we're at right now. The middle section of my presentation will deal with some solutions. Immediate solutions we can do within the law enforcement community and the community itself to improve relations. And then ultimately, the ending of that will be dealing with further things that we can do on a long-term and national basis. Some of what I'm going to say is going to irritate you. I just want you to know that. Bear with me and let me get to the end of it, and then we can clean it all up. In 1935, Berger versus United States, the U.S. Supreme Court said this: the prosecutor represents a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest is not that it shall win a case, but that justice shall be served. In 1963, the United States Supreme Court talked about Brady versus Maryland. Brady versus Maryland is a landmark case that basically said prosecutors must disclose all exculpatory and material evidence that would help the defendant. And it went so far as to say it must disclose information that's in the possession of law enforcement, whether the prosecutor knows about it or not at the time of trial. So it tied into Mapp versus Ohio, where they're the fruit of the poisonous tree, and what happens when we violate people's rights. You lose those evidence. So it tied back into that so that law enforcement would be penalized and prosecutors would be penalized if they didn't disclose all the necessary information. So since 1963, over the last 50 years, I'm going to hit a highlight of some of the major violations, the Brady violations, that the U.S. Supreme Court has seen. The first one is Giglio versus United States in 1972. This is where the key witnesses testified that they had not received a promise of leniency, even though they had. And that was not disclosed to the defense counsel during the trial. In 1976, United States versus Eggers, the defendant was convicted of murder even though he was claiming self-defense. And what wasn't disclosed was the violent history of the victim, the person that was murdered. That resulted in an exoneration for this individual because of his history. He was actually, it was a self-defense claim. Bagley, 1985, the defendant requested from the prosecutor any deals, incentives, or promises that were made, and the prosecution failed to disclose these. What they failed to disclose, that two of their key witnesses were undercover agents for the alcohol, tobacco, and firearms. And the court ruled that it denied the defendant impeachment rights or opportunities to impeach the witnesses that were presented before the jury. In 1995, a defendant, Kyles versus Whitley, defendant was convicted of murder, and prior to trial, the police had collected evidence from eyewitness statements saying that the physical attributes of the defendant did not match the murderer. That was never disclosed. Banks versus Drakey in 2004, the prosecutor failed to disclose that one of the key witnesses was a paid informant and that the other witness had been coached, and then they failed to correct the record when both of them testified and lied about that on the stand. And then we have Smith versus Kane. It's a trial of key witnesses pointed out the defendant, when asked if they recognized the murderer, the woman pointed right to him and said, "That's him, I'll never forget him." What wasn't disclosed is that within an hour of the murder, she said she never saw the defendant's face and she couldn't identify them. That was never disclosed to defendants. And then finally, in 2014, a judge in Orange County disqualified the entire Orange County prosecutorial staff from handling anything to do with the death penalty case. And the reason he did that was because it was discovered late that the Orange County Prosecutor's Office, with 250 prosecutors working for it, and the Orange County Sheriff's Department had maintained a database of jailhouse informants and never disclosed the information they had to defense counsels in certain cases. Now, then more recently now, if you've been watching Facebook, you see that the Baltimore Police Department is in trouble because not only once, but twice they failed to turn off their body cams when they were planting evidence. And 40 or 50 cases, I don't remember how many, were thrown out just recently. This destroys public trust. Now, I'm going to talk a little bit about exonerations. Exonerations from 1989, there have been 1,576 exonerations. Not a lot, when you think about nearly 1 million people are convicted a year. Of that 1,576, 46% of them were a result of official misconduct, either law enforcement official misconduct or prosecutorial misconduct. That is 725 individuals that have been wrongfully convicted since 1989 that have been proven to be correct. Now that's only the individuals on the misconduct. The other ones are due to forensic advancements, DNA, that kind of thing, where there was no misconduct. It just happened to be science had advanced to the point where we could actually prove better whether or not they were involved. Of those 725 of them, the average stay in prison has been 20 years. Some have been over than that. Some have been more than 30. Once you're convicted, it is very difficult to get back before the court and get your case reheard without producing additional evidence to the contrary or inadequate legal representation. And again, the percentage we're talking about is small. It's less than 1%. But the problem is there is no database to track these. There's no way of knowing about official misconduct until it's been discovered. So the question is, how many more could be sitting in prison that are innocent and have been put there because of prosecutorial or law enforcement misconduct? And 97% of all criminal cases never go to trial. They're done through a plea bargain. The problem with prosecutorial misconduct and stuff being hidden is people are being forced into accepting pleas or pleading to something because, one, they don't have the money to fight it, or two, the evidence hasn't been disclosed to them. So I'm a big proponent of open records, and we'll talk a little bit more about that. Now, the ramifications for official misconduct, this is really disturbing. Less than 2% of proven official misconduct has resulted in anything more than a reprimand to somebody's file. In fact, in the Orange County case, it's still working its way through, but the prosecutor's office appealed the judge's ruling. It went to the state attorney general. The state attorney general said, we think the judge was wrong in law. By the way, we're going to do an investigation on this and determine whether they're... How do you do that? If you already said you believe they're wrong, how do you get to do an internal investigation on the fact? And nothing was done, and that particular state attorney general is now a senator of the United States Congress. So why is all this important? I'm getting to the positive part now, guys. Service recovery. What is service recovery? A service recovery system is nothing more than an internal strategy that determines how an organization is going to deal with a service delivery failure. Every service company will have a failure. How they deal with it is going to determine what the community does with it. In fact, there's a thing called the service recovery paradox, which basically says if you are a service company, and all government is, if you're a service company and you have a failure, if you do nothing to correct it after the complaint comes, you have a 9 to 19% chance of ever doing business or retaining that customer. If you attempt to do it but can't solve their problem, there's a 19 to 32 or 34% chance. So 2/3 of their feeling about you has gone away. Now it's negative. If you perform the way you say you're going to perform, and you provide an average service, it's a 50-50. Will they like you as an organization? Will they not? Will they buy from you again? Will they not? It's about 53%. But if you have a service failure and you correct it, according to the satisfaction of the customer that's complaining about it, there's an 83% chance they'll come back. That'll happen one time. You get one shot at it. After that, that paradox goes away. So what does that mean? If we can have systems in place where our lowest level employee can solve the minor problems on the street level, the organization is viewed as responsive and a good quality customer service provider. Customer loyalty depends on three things. The first thing the customer wants to see when there's a service failure is that you accept responsibility for it. We screwed up. We made a mistake. And you acknowledge their dissatisfaction. The next thing they want to see is they want an explanation of what happened and why it happened and what you're trying to do to fix it. And the third thing they want to see is an adequate compensation for their time and their effort to complain. Now that doesn't necessarily mean cash. It doesn't mean that you have to give them money. It means you will come to some resolution that they're comfortable with and they're happy with. Okay? Incidentally, employee retention follows the exact same thing. Employees want the company to assume responsibility for something that's gone wrong in their work history with that company. They want an explanation provided for the failure, and we'll talk another thing about this in a minute. And they want to be adequately compensated. Now that doesn't mean money again. We're not talking money. They want to feel like their voice has been heard and something has been done. Now employees, if you do any human resource studies, employees between 12 and 14 months of their employment, they've gotten to the point where they feel they've got their job. They want to see what the next step is within the organization. What do they have to do to progress within that organization? And if they're not given a solid track record and an ability to do that, within 24 to 36 months, they're leaving for your employer, for your competition. They're going somewhere where they can get that trajectory for them. Okay, anybody feel like this sometimes? Yeah, we're not doing that anymore. We're done. And there are people out there that quite frankly will generate this kind of reaction from you. Okay, let's talk a little bit about employees and customers, employees, and media issues to consider. If there's no respect for the organization or the leadership in the organization, whether it's from employees, whether it's from customers or community members, or whether it's from, I lost my train of thought, employees, community members, or the media. If there's no trust, there's no respect. And I reversed them, no respect, no trust. And then if there's no trust, there's no retention. So what does that mean for law enforcement? Typically, law enforcement takes the role with the media that, hey, we'll get to you when we get to you. We can't disclose a lot of this information. We'll get you some when we can. And the media hates that. What happens when you're left with a void of information? Most people fill that void with negative information. Anybody work with this guy? Or somebody like him? I used to supervise guys like this. I just wanted to lighten it up a little bit here. service perspective now. Few companies think of their customers as annuities or ongoing sources of income. Frederick Reinheld of the book, with the book Loyalty Effect, wrote this. But what's the reality here? We know that customers become more profitable the longer they remain with an organization. So if we're talking community members in a government thing, the more a person feels comfortable with the organization, the better of a community member they become, and much more of an advocate they become for your organization. We also know that they become a marketing vehicle through positive word of mouth statements. When a media comes out and says, this officer was racist and shot him because of person of color, a loyal customer will, no. We know that department, we know the leadership in the department, they're not going to put up with that. That's not a correct statement. We can have that kind of support from the community. And we know that highly satisfied customers are willing to pay a premium for quality service. Now, what does that mean for government? What this all means is that if you have a relationship with your community, and it's a good relationship, one, they're going to support your organization. Two, they're going to become marketing vehicles for you. And three, they're going to be willing to pay the extra money. So in a government situation, as an administrator, the police department and the public works department are the biggest consumers of the budget in any municipality you want to look at. Police departments run between 34 and 42% of the entire budget for the organization, the municipality. Public works is slightly less than that, depending on the city or the community you're in. When you're competing for dollars, you need the community support for you, because when it comes to the point that whether the city council or the community, the county commissioners are going to raise taxes 3%, you need community members in those meetings saying, we have a good police department, we have a good probation department, we have a good community officers department, we need to support them and we need to keep them strong, and we're willing to pay that 3% to make sure we don't take a cut there. The converse of that is, if you don't have it, the first thing they're going to do is attack the two big departments. They're going to attack public works and they're going to attack law enforcement, saying, we don't need this many. They're not that good anyway, cut their budgets. So let's talk about some of the solutions, because I'm running tight on time. Engage the media. That is a strange thing for law enforcement. Law enforcement and the media have a love-hate relationship. I did as a chief, I worked hard to keep the media happy, and I felt like there was nothing I could do that would ever keep them happy. But I tell you, it works, because in 2013, Las Vegas Metro Police Department decided to take a lot of these principles, not because I said them, they decided on their own, and because I don't think Las Vegas Police Department knows who Jerry Summers is, nor do I think they care. They decided to become more proactive with the media. And what they did is they said, at the time we have a critical incident, rather than trying to keep it from the media, we're going to call them and tell them we have a critical incident and where they can respond to. They then respond to that, and they have a PIO officer or a sergeant or a lead detective there to give them a briefing. And the briefing goes something like this. At 2 o'clock, we had two officers attempt to make a stop on the vehicle. The suspect, who was a known, was suspected of, let's say, armed robbery, jumped out of the car, a short foot pursuit established. They turned down the alley. The suspect raised a handgun at the officers. The officers fired 7 rounds, striking the suspect 5 times, and he was pronounced dead at St. Luke's Hospital, whatever hospital it is. That's about all they're going to give them. We'll give you the officer's name. We'll give you information as we can. Next of kin notified, those kinds of things. then within 7 days, the Bureau Commander or the PIO officer will come out with a videotaped statement of what occurred, a summary of what occurred. And in lethal situations, within 84 to 86 days, they have a full-blown press conference where they give the facts, they open it to answers, questions, and they answer what they can, and they put it on their website. Since they've done that, their community support has gone through the roof. In non-lethal incidents, it takes them about 106 days. So the community knows now that when an incident occurs, there's going to be a 90 to 120 day delay, any real information. The press knows that, and they know they're going to get the information as it becomes available, so they back off. They're not writing horrible things about Las Vegas Metro. So that's a key element. And the next thing I'm going to talk about is removing the exemption for Idaho Code Section 9340C1. That is the exemption for the release of personnel records. Now, this is a touchy subject, I know. I personally believe personnel records of officers and anybody in government should be made available to the public after an investigation's done, with the appropriate redactions. And the reason for that is that who is paying for the funds for that organization? It's the community. The community has a right to know what is going on with individuals. Now, it's a touchy thing because people in private sector will say, our records aren't exposed like that. That's true. But the people who are paying your salary in private sector know if something's going wrong. And they decide whether or not they're going to keep you or not. The other thing is you chose to go into government work, and government work requires a higher scrutiny. The officers are sworn to that. People in government just understand that it's going to require a higher scrutiny. If you don't like it, go to private sector. That's a harsh way of looking at it. And I am in the process of drafting legislation to change this in Idaho and then nationally. One of the reasons as an administrator I had a problem with is when I fired an officer, the local press would beat me up and they'd say, well, what's going on? Does he not have the ability to manage correctly? And I couldn't say anything. I couldn't give them anything, but I would love to have somebody open the files of the 22 or 23 officers I fired in 9 years and look at the steps I took. What you would find is I was following our policies and procedures, I was doing progressive discipline correctly, and then I was getting to the point of termination, and that termination was being ultimately approved and signed off by the city manager. None of that came out. None of that has still come out. Work nationally to do the same thing. I think it's time that we understand that the community has a right to know. And the other thing that this does is if the CEO or the chief or the head of the city manager are hiding things, inappropriate actions, by making it public, the community gets to know and they get to remove that administrator that's not working according to the way they want their organization run. Law enforcement needs to follow and enforce the code of ethics internally. That's a problem, and we have a statement right there that says integrity without compromise. I can tell you there have been officers that I asked to be decertified and they were not from Post Academy. And the reason they were not is because they were concerned about taking away their private property rights for something that seemed minor. Now, we swear to a code of ethics, and that's why I think there needs to be some sort of internal steps for the code of ethics as well. Suspension for instance, if you have a crime when you apply for the Post Academy that exempts you from getting certification, you can't be a cop. If you commit that same crime after being a cop, you're not necessarily decertified. Why is that? If it's going to keep you out from getting certification. If you commit the same crime and you're convicted of it, your certification should be removed, in my opinion. That's a hard statement, but we have to start doing that because the community doesn't trust us anymore. If you look at Ferguson, and I'm going to finish this up real quick, we're almost done. If you look at Ferguson, Missouri, and you look at the forensics of the Michael Brown case, Darren Wilson, the officer involved, did everything correct from a law enforcement standpoint. Didn't do anything wrong. Handled himself appropriately, that led to the death. Yet and it's been proven now in court that he didn't do anything wrong. The problem is that he became a casualty of the culture of the organization he worked for. And there's something wrong with a culture that a community can react that way over an incident like this. There's a distrust that's there. And as organizations, we need to work to build the trust in our communities. Demand the courts hold attorneys to the standards of their code of ethics. I can tell you on every prosecutorial misconduct thing I posted up here, it violated their code of ethics according to the American Bar Association. I think it's Rule 8.1 if you look at it. And they're not being disciplined. Judges are not holding, when they find the facts, they're not holding the prosecutors accountable for it. They're not allowing the defense attorneys to hold them, and then the judges aren't holding other judges that are ignoring the Brady violations accountable. So it's a systematic problem. It's not just a law enforcement problem. Finally, ADAPA rules need to be, and we talked about suspension of certifications. Some states do this. North Dakota is very good at it. If an officer, for instance, gets a DUI, well, you're going to lose your license if you blow. You're going to lose your license for 30 days. Absolutely. Then you can get a 60-day thing. North Dakota says, okay, if you're a police officer and you get a DUI, you should have known better. It's a moral and ethical violation, and as a result, we're going to suspend your certification for 90 days, whether your department does it or not. You can get it back after that. The second offense, then it's suspended for 5 years. And if you get a third DUI, I think it's within a 10-year period, you lose your certification. And they're holding it to it. And we're seeing better actions with North Dakota that way. And decertification right now needs to be left for egregious violations, I believe. I think there should be progressive discipline before you ever get to that, unless, and one of the most egregious things that we see a lot of was officers having sex on the job, using their power of authority to have an attractive woman give in and have sex with them, or we're seeing some lewd and lascivious acts with minor females and males. Those are egregious. Those deserve decertification immediately. Okay, any questions? The end result is, and I came close, I went over a little bit. The end result is, in today, we're more concerned about lawsuits than we are concerned about customer service. And we need to get back to the original basis, Sir Vincent Field said, of the police are the public and the public are the police. Any questions? There you go. Thank you.